Union Basics. What you need to know as managers. First things first, you need to know the law. Should the company unionize, you will need to become familiar with the following laws: the NORRIS-LA Act, the National Labor Relations Wagner Act, Labor Management Relations TAFT HARLEY Act, Labor Management Reporting and Disclosure or Landrum-Griffin Act. There are additional laws that affect labor relations. Among them are the Employee Retirement Income Security Act of 1974, the American with Disabilities Act of 1990, the Bankruptcy Act of 1984, the Worker Adjustment and Retraining Notification Act, the Racketeer Influence and Corrupt Organizations Act of 1970, and employment discrimination laws and executive orders. Remember, as managers and supervisors, you are not eligible for coverage under the National Labor Relations Act. Therefore, should the company unionize, you will not be part of that union, nor qualify to be part of it. The NORRIS-LA Act, also known as the Federal Anti-Injunction Act. This law limited the power of federal courts to issue labor injunctions. Activities that had previously been routine by judges were now protected by law. For example, peaceful striking or encouraging employees to join a union. It also prohibited the yellow dog contracts. These contracts were agreements where employees would promise their employers that they would not seek to join a union. Next, we have the National Labor Relations Act, also known as the Wagner Act of 1935. It offers legal protection for employee rights under Section 7. Under this law, employees have the right to form or join a union, bargain collectively, and engage in other concerted activity for mutual aid and protection. Section 8 of the Act prohibits unfair labor practices by employers. Employers are not allowed to interfere or coerce employees as they exercise their Section 7 rights. This law also covers non-management employees in the private industry. It also established the NLRB, which investigates, and we will talk about that further. The TAFT-Hartley Act, also known as the Labor Management Relations Act of 1947, prohibits unfair labor practices by unions, making it illegal for a union to engage in actions that discriminate against any employee's exercise of rights. Under the Act, unions cannot threaten workers who refuse to join or support a labor union, bargaining in good faith, or strikes against employers who are not involved in the labor dispute, just to give some examples. This act also prohibits closed shops, meaning union membership is not required in order to be hired. It also protects the rights of individual employees and employers involved in the labor relations process. The act also clarifies that managers do not have a legal right to unionize, nor do managers have a right to keep their job if they publicly speak out against an employer's labor policy or bargaining position. The Labor Management Reporting and Disclosure Act, also known as the Landrum-Griffin Act of 1959. It is designed to protect the rights of individual union members and their relations within their own union, and to ensure that labor organizations operate in a democratic and financially responsible manner. Non-union employees are not covered under this law. It also sets procedures for readdressing internal union problems. It also gives members the right to own a copy of their collective bargaining agreement. There are bodies that govern these laws and that oversee to make sure that everything is running smoothly. They are as follows: the National Labor Relations Board, as previously mentioned, Federal Mediation and Conciliation Service, U.S. Department of Labor, National Mediation Board, state and local administrative agencies. Goals of the company and the union. Management and unions have goals that are similar. However, they also have goals that may conflict at times. This means that what the company wants and what the union wants are similar, but that may not always be the case. These goals provide direction and serve as the basis for the company's strategies, plans, and organizational structure. In other words, you have to negotiate. Expect some changes. Before evaluating the new strategy, if unionized, it is important to note that the decision-making process changes. Decisions will now be based on negotiations and upon review of the collective bargaining agreement. By adopting a codified business-like strategy, the company will remain neutral in union campaign and maintain straightforward strategy approach. Accommodation or labor management cooperation approach will give opportunities for dialogue between management and union, which will facilitate communication and empower the employees. When managing employees in a union, you must always refer to the collective bargaining agreement. This is what was negotiated. When in doubt, it is the first place you need to look. It is a negotiated agreement. Don't forget that part. And it's also a legally binding document. And it is there for you to reference. What you do not want to do is assign any duties or assign extra shifts without first referring to the collective bargaining agreement. Common sense is not always so common when dealing with unions. So you definitely want to make sure that you always have this to reference. The end goal is to stay out of legal trouble, and here's how we do that. Avoid unfair labor practices. Do not interfere with the employee's rights. Do not discriminate against any employees. Do not offer benefits in return for them not joining a union. Do not interrogate of union activities. Don't threaten to discharge or refuse to hire union supporters. Do not threaten pro-union workers with poor job assignments or termination. Do not use company spies to learn of who was organizing the union. How do you manage in a unionized environment? It may seem scary, but you have this. You have to be able to adapt to change. Never act or make decisions on impulse, as it may come back to bite you. Always remember, the union does not run the company. There is an agreement. So refer to that agreement and always follow the rules.